Sure. So free speech usually refers to people's ability to say what they want to, say what they think is right. Sometimes just as a matter of self-expression, that you want to convey your views. Another reason that speech is important is because it's a facet of democratic self-government. That if you're going to have a democracy, if you're going to vote on candidates and on ballot measures, well, then you need to be able to talk about why you should vote for or against one or another. And it also is understood as a means towards other ends besides democracy, such as search for moral truth or for religious truth or for scientific truth. So for all these reasons, free speech, which by the way is usually used quite generally to refer to speech, refer to printing, refer to handwriting, refer to symbolic expressions like waving flags, why that is important. Now this having been said, while speech is broadly protected, certainly in the United States, but also in most other democracies, all democratic regimes have some restrictions on speech. One classic example is saying to somebody, do this or I'll kill you, is literally speech, but is generally speaking constitutionally unprotected speech in the US. Likewise, there may be so-called content neutral restrictions. So if you want to use loudspeakers in the middle of the night in a residential neighborhood, that may literally be speech, but it may be restricted, not because of what you're saying, but because of the noise you're making while saying it. Likewise, when the government is acting as, say, employer, it could say, well, when you're on the job and you're dealing with customers, we expect you not to use vulgarities. Otherwise, in political debate, you're free to do that, but not when you're acting as an employee. So there are all sorts of restrictions on speech in all countries, I imagine. But the broader principle of free speech, I think, is broadly accepted as important in all democracies because it is the fundamental way in which people make democratic decisions worthy of the name democratic. You don't really have a democracy if one side isn't allowed to explain why their candidates should be elected.
Well, Robert, I mean, we'll talk about this, but that's the tendency in the fight that we've been noticing is that there have been more and more restrictions or limitations placed on what would otherwise be the protected form of free speech. And I've been finding these days the label, the catch-all label that everyone's been given it is misinformation or disinformation in order to qualify it as unprotected speech that the free speech platforms can thereby censor. And it's an interesting thing is that there's just been a slow chipping away gradually over time in Canada to the point where, you know, we're calling things unprotected speech for the purposes of regulation and banishing it from social media, whereas it's not clear what is the protected speech that platforms, neutral platforms, have to respect and what they don't. And they seem to be gradually, with increasing momentum, chipping away what would otherwise be, normally speaking, protected speech.
I mean, no, I think
well,
you have sorry.
No, I'm sorry.
Oh, I was just going to say you have the idea of free speech, which is the cultural idea of free speech, which is much broader than its constitutional protection, than its legal expression. And I think that's,
right.
And we've seen a major sort of controversy over the past decade or so, but particularly the last 5 years or so, about where people's idea of free speech doesn't find constitutional protection, doesn't find legally cognizable expression in ways that has surprised at least a portion of the population in various nations. And we see, in my view, the greatest assault on the idea of free speech, both as a cultural ideal and as a constitutional protection that we have in maybe a century, in the sense that, you know, not only on public university campuses, but just as an example, the Trump impeachment aspect, where you have leading constitutional professors who have become congressmen, like Congressman Raskin, saying the First Amendment has no application to what Congress does as it relates to impeachment. Carving out exceptions to the First Amendment's never a good path to go down historically. You have law professors appearing on, or legal scholars, appearing on CNN saying that the First Amendment doesn't protect anything except true speech, which is extraordinary. You know, so I think we're seeing an attack culturally and legally on the idea of free speech, and people are seeing what happens when private entities really monopolize the public square. What do we do about that? Because then the cultural idea of free speech doesn't really matter much if it has no constitutional protection in the most important platform that exists, though clearly the Constitution doesn't explicitly apply to private actors. So I think we're seeing extraordinary challenges.
Well, I think we are seeing challenges. I think it's important to separate the nature of the challenges. There are at least three things I think going on in this discussion. One is, to what extent do our free speech principles apply beyond governmental restrictions and apply to things like private platforms? And the answer is to some extent, although it's a complicated extent. So for example, I think most of us would say that if, let's say, Harvard, a private university, expels a student because he says something anti-government or pro-government, pro-Trump or pro-war or anti-war, that would be a violation of free speech principles. It's not a violation of the Constitution. The First Amendment, by its words, by its terms, applies only to the federal government. It starts with Congress shall make no law. 14th Amendment applies that to states and local governments, no state shall. But we can certainly talk about free speech principles applicable to something like a private university. On the other hand, if, let's say, the National Review, to take an example of a conservative magazine, or the New Republic, take an example of a liberal magazine, decides not to run a story or print an article because it doesn't like its message, that's probably, we wouldn't say that's a violation of the author's free speech rights. If anything, it's the exercise of the magazine's own free speech and free press rights. And it's valuable to us as readers, right? Because the reason we subscribe to a magazine or a newspaper is as much for what it leaves out as for what it includes. So one interesting question is, where should various entities be placed on that continuum? So for example, should social media platforms be treated like newspapers or magazines, where their decisions about what to allow are unregulated, in fact, are constitutionally protected? Or should they be treated as kind of like a telephone company, whether landlines or cell phones, where they are treated as so-called common carriers under American law, where they have to allow everybody, and they can't just cancel your phone number because they don't like what you're saying in your telephone conversation? So that's an interesting and important question. A second question is, how should free speech apply in situations where the government isn't throwing someone in jail, but for example, is deciding whether they should be kept on as an employee, or is regulating the speech of students at schools? Or you point out impeachment. So again, it's an interesting question of where exactly you place impeachment. So let's say that somebody loses an election because of their speech. Well, that's elections for you, right? That's perfectly proper. And certainly people routinely lose elections because they're a party that the public doesn't like, the voters don't like. Well, that's their First Amendment right to join the party, but they don't have a First Amendment right to be elected. What about a recall? I don't know how it is in Canada, but in many American states, it's possible to recall candidates. And in most of them, the recall can be for anything the voters please, including, I just don't like this person's speech. So on the other hand, the Supreme Court held in a case called Bond v. Floyd in the mid-1960s that a legislature can't just say, we're going to exclude somebody from the legislature who is duly elected by voters because this person has said things that are against the war and we're afraid might lead people to violate the draft obligations. So one question is, where does impeachment fit there? So if the impeachment is more like a recall, then there would be nothing wrong with Congress saying, we don't like your speech, we think it's bad for the country, we're going to recall you from office, as it were. On the other hand, if impeachment is more like the exclusion from the legislature in the first place, and again, it's an analogy, obviously it's not the legislature, then we might say that is a violation of First Amendment rights. So that's an interesting question. And the third question, returning to the first point that was mentioned, is what about misinformation? Well, it turns out that First Amendment law has long had a very complicated set of doctrines having to do with misinformation. So throughout American history, people could be sued for libel, even prosecuted for libel, which is to say misinformation, fake news, lies, if you just prefer the term, or sometimes even honest mistakes that damage a person's reputation. First Amendment has never been understood as categorically protecting that. It's always left some role for courts to say, this is damaging to a person's reputation and it's false, and you, the speaker, have to pay damages or even have to go to jail for that. Likewise for fraud. If I get you to contribute to my charity. Charitable contributions are protected by the First Amendment, and so are solicitations. But if I lie to you about how much money is actually going to go to the charity and how much into my pocket, that is punishable. So one interesting question is, what about other kinds of alleged lies? About, for example, the deficit or the election or the government or about history or whatever. And the Supreme Court has generally said that most such lies are protected, but that's been kind of unsettled. It was decided really only 9 years ago in a case called Alvarez in 2012. But on the other hand, when they get specific enough and concrete enough and damaging enough, then they might be punishable. For example, if they are lies about a particular person, or maybe if there are lies during an election campaign, or especially about the mechanics of voting. What if you were to say somebody, oh, you should go to vote at this polling place, hoping they show up at the wrong polling place, because you're telling them the wrong polling place, you know it's the wrong polling place, hoping they don't vote as a result. Is that punishable? Possibly. The Supreme Court suggested that it might be, but again, it's a complicated question because for over 200 years, this question about when disinformation or misinformation can be punished under the First Amendment has been a complicated question.
But that's where there's an interesting distinction, is where you say punishable free speech implies a prejudice, which that can therefore be punished or can lead to a punishment. But talking about the common carrier and platforms saying, well, we're gonna censor disinformation, even though there has been no one who has been sanctioned, as opposed to letting the courts dole out the punishment. That's where there becomes a very big problem in terms of the ever broadening scope of what's misinformation. Right. And in Canada, we have laws against hate speech, the ever broadening scope of what is included in hate speech. And there was one. So go for it.
No, go on. I'm sorry, I shouldn't interrupt.
No, I was going to say that in one particular Supreme Court case, there was a passage that suggested hate speech could include speech which is even true, accurate, if it would tend to hurt, which, and in Quebec, defamation, we're the exceptional province, can still be true if it is framed in such a way as to cause damage, and not like the private disclosure, a public disclosure of a private fact. So you get to these points where you don't even have the government doing it. You have these monopolies doing it de facto for political purposes, which comes to be the same thing, but no remedy for it.
Right. So this is, again, a very interesting question, a very complicated one that I'm organizing a symposium, a symposium for law professors about this very issue. What should we think about platforms' editorial decisions in this kind of situation, or perhaps editorial prejudges, platforms' decisions about whom to block and what to block? So again, one possibility is to say it's kind of like a newspaper's or a magazine's decision, or to take an example of even more powerful speakers, at least in the past, it's kind of like a broadcaster's decisions, where those are the exercise of their editorial discretion. They're either unregulated or somewhat regulated when it comes to broadcasters under American law. But there's something that we expect them to make decisions about what to include and what to exclude, and without any due process. Nobody says that if you write a letter to the newspaper and the newspaper decides not to publish it, it has to give you a trial or has to give you a written opinion about why it didn't publish it. They could just say, we think you're kind of a fool and your speech is kind of foolish and we don't want to foist it on our readers. They could say that, or they could say nothing at all. They could just refuse to publish it. On the other hand, as I said, some things like phone companies are treated as common carriers, and one question is, should you view the platforms as more as the common carriers or more as the newspaper? One other factor is, of course, on one hand, platforms can't throw you in jail. They can't take away your money. They can maybe diminish your chance of monetizing things, but they can't just go out there and send the marshals in to seize your property. So that might be a reason why we would say we should be more open to them using what are, after all, their private property rights to decide what to allow and what to disallow there. On the other hand, you might say, especially when they're powerful enough, at least if they were the government, then they would have to provide these procedures. They might have to write written opinions. There would have to be an opportunity for notice and to be heard. Whereas here, even though they don't have the power to lock you up or take your money, they're still powerful enough that we should be concerned about their kind of unreviewable, unexplained discretion. So these are complicated questions. Yeah.
Some people say that they've become more powerful than the government.
Well, let's not exaggerate that. They can't throw you in prison. They cannot seize your home. What they could do is they could make it harder for you to communicate to your audience, your prospective voters. Not impossible by any means, but a good deal harder. And one question is, should we be worried about that? So I totally agree. We ought to be in some measure worried about it. But again, we shouldn't overstate it. Just to give an example, an early case from about 100 years ago, where the court upheld restrictions on speech, was called US v. Debs. And Debs was, in fact, a candidate for office. He was the Socialist Party candidate. He obviously never got close to winning, but he'd get millions of votes. And he was thrown in prison for giving a speech basically defending draft resistors during World War I, on the theory that that speech helped contribute to illegal failure to comply with draft applications. That's the government throwing a candidate into office, into prison, not into office, into prison for their speech. Whatever Facebook can do to a candidate, or whatever Twitter can do to a candidate, it's not that. So I don't think it's helpful to kind of exaggerate the effect of it. On the other hand, if you're worried about corporate power over elections, as some people are, by the way, mostly liberals historically have been worried about that, but conservatives could be too. If you're worried about corporate power over elections, then you might say, even though they can't throw you in jail, if they can swing an election, especially a close one, a little bit, we should be concerned that these wealthy corporations with their own set of interests, often self-interest, but maybe ideological interest that was never voted upon by the public, run by very wealthy people, would have this immense power. We might be concerned about that.
No, Eugene, the liberals were concerned about it until they became aligned somewhat politically, and now they're no longer concerned about it. And we've seen in real time what happens when these powers
To be
align.
fair, conservatives used to poo-poo the concept of kind of undue corporate influence over elections, and now many of them have discovered that they're concerned about it. And it's easy to tell a story, this is hypocritical. I'm not sure that's that. I think part of it may just be that people, as they're exposed to things, begin to see the downsides of things and the upsides of other things, and it may sincerely open their eyes to certain things. So maybe conservatives have become more open to the risks of corporate power, and liberals may have been more open to the notion that if there is and there's lots of misinformation indeed in the public. If there is some such misinformation, maybe it is causing real harm that we would like somebody to be able to step in. So it used to be that the liberals would say, question authority, and conservatives were into more authority. Now, liberals are often saying, no, you must follow authority, and the conservatives are saying you should question it. Maybe the answer is that there's a little bit of both. There should be a lot of questioning of authority, as well as at the same time, openness to the possibility that we might want to have some intermediaries. Historically, it's been the mainstream media presenting things that are particularly likely to be true and unlikely to be false to the public.
When I think the other factor there is you have this sort of intersection of free speech and free press, which has under a fair doctrine has been constricted that as long as you're not making a specific factual claim that or have reason to believe is false about a specified individual, it will be protected speech to such a degree that we say ideas cannot be false by definition.
Right.
But what's interesting is at least the Alex Jones cases start to erode that, where now all of a sudden, if you make a controversial statement about a major public trauma or criminal event, and people that have are within, quote, the emotional zone of danger of being impacted by your theories about that event, can now sue you for intentional infliction of emotional distress purely for your speech, even if the person suing you, the defendant never talked about them ever, never said anything specific factually about them, never even mentioned them by reference or by name. And I'm concerned with what that means on the one side for that intersection of free speech and free press. And on the other side, I think where big tech has become more publicly controversial, aside from the general point that's good about what happens when private institutions have a disproportionate, disparate public impact beyond that may be anticipated by the Constitution itself, is the Section 230 issue. That it seems like big tech has the benefits without the burdens. They have all the benefits of speech.
That's right.
In the sense of whatever could be labeled as free, the expression and protection of their own property interest. But they have none of the burdens in that they can editorialize and can't be sued. They can make false statements and can't be sued. I mean, unless they themselves are specifically doing so, then sometimes. But to give an example,
Right.
Section 230, like let's say somebody wanted to sue Twitter on the grounds that Twitter made a promise to the public that they would be the free speech wing of the free speech party. And based on that, they believe they were that Twitter's been unjustly enriched and committed a form of consumer fraud because they have now violated that promise. Let's say under that theory. Section 230 has been interpreted so broadly that basically Twitter can lie to its consumers, and for the most part, there's some exceptions, but in many instances that a different business would not have protection. They have a scale of protection under Section 230 that is unique somewhat in the field of speech, that they get all the freedom of speech without any of the responsibility or accountability of speech when that speech is not free because it's fraudulent or something else. So that's where I think some remedy of Section 230, of linking Section 230 immunity to when you're a pub, you effectively have monopoly power over something like the public square. You have to abide by free speech principles if you're going to get the carrot of Section 230 immunity. Otherwise, it's withdrawn. There's arguments that Section 230's good faith provision was kind of meant to do that, but it's judicially been unenforced for a while. I think has some application, but it's the problem. I mean, the only other time we really dealt with this a little bit with the Prunier Doctrine in California and its predecessor in the U.S. Supreme Court was when you had company towns. Where company towns effectively said, well, we can prevent union petitioning and political activism because we'll own the streets, we'll own the square. And the Supreme Court's remedy for that was, no, if you choose to literally a private company own the public square, you can be held responsible. Now, they backed down quickly from that on the U.S. side when it was applied to malls. California did extend it to malls, but hasn't extended it since then. And I think once you have monopoly power as a private institution over something like the public square, where a core principle of a cultural principle of free speech is at risk, then I think some conditioning of that, in exchange for the monopoly power you enjoy, you have a responsibility to the public to protect something as shared as value as free speech is. And I think that's a potential remedy, though it may be a remedy that requires statutory amendment or some carrot stick approach because of the legitimate issues of you're infringing on free speech if you start restricting it, even if it's Twitter's free speech at issue.
Yeah, and Eugene, one thing from before where you said, let's not exaggerate that these are private companies. They're not as powerful as the government. They can't throw you in jail. It's not to be hyperbolic or to make inflammatory comparisons. I think in a way that they are actually more powerful than the government because they can do certain things which are tantamount to putting you in jail, put you in social media jail. They can cut off your ability to make money, to gather money, to collect money, cut off your PayPal. Bank institutions, private institutions are shutting down people's accounts for speech reasons. And they can do all of this, which is even worse than putting someone in jail. And they can do it with impunity because you can't go after them because they're not the government and they're not held to government standards. So they have more power and it's even more dangerous because at the very least, if the government puts you in jail, there are checks and balances, and here there are none. And, the common carrier idea is one that I thought, always would have been the one to adopt, especially with, Google, YouTube, these platforms that have well over 80% of the market share. And so I was disappointed to see the courts systematically not go that way. But I think the courts should have gone that way. And the fact that they won't means that there's, fewer remedies available. And one of which is, Barnes's this idea of an amendment to the 230, which is if you want the immunity or the impunity that comes with what you do, you have to offer some of the protections that a government institution would otherwise have to offer. But to say that they can't throw you in jail so they're not as powerful as the government, I think actually what they can do is worse and more powerful because there is no check or balance on what they do and who they do it to and why they do it.
Well, so I think there are a bunch of things going on there. Let's break them down into four. So one is, I can't speak to the details of the Alex Jones lawsuits, but I will say that indeed, when it comes to American law, there can't be an intentional infliction of emotional distress lawsuit when speech is on a matter of public concern, unless it's libelous or involves a threat or some such. So to the extent that somebody says, I'm just really emotionally wounded by things you're saying about this controversy, unless it's libelous or a true threat of violence, under a standard First Amendment law, that speech should be protected. Maybe lower courts are making a mistake, but in any case, let's set that aside. A second point is, I do think that in principle, you should be able to sue for fraud or breach of contract if a service says, we will allow your stuff to be up indefinitely, and then it takes it down. If there's a contract, there's a contract. From what I've seen of the cases that have made that claim, they have overstated the supposed promises that lots of businesses may say in general. Yes, we believe in great customer service. Yes, we're for free speech. But if you look at the contract and they say, we reserve the right to do this and that's the contract, not their big picture statements, what is sometimes called puffing in the law of contract. So again, let's bracket that. And the third thing that I'd like to bracket before we get to the fourth thing, which I think is really interesting and important, is this notion about social media jail. I'll tell you, I've never been in real jail, so I can't say I've been in both. And but I have a sense of what real jail is like. And I would rather spend a week with all my social media accounts blocked than a week in jail. I'd rather spend a year with all of my social media accounts blocked than a year in jail. In fact, I'd probably rather spend a year with all of my social media accounts blocked than a week in jail. I don't want to deny that there's a real issue out there, real possible problem. But I don't think we should believe our own metaphors. The fact that we call something an online lynching, well, you could call it that, but it's not a real lynching. It's not really social media. Social media jail isn't really jail, and I don't think should be confused with that. But turning to Robert's point, which I think is a very important one about Section 230, is there's no doubt that Section 230 gives social media platforms very peculiar, by the standards of the law, protection. And it does so quite deliberately. And then the question is whether that judgment was sound. So let me briefly lay this out, and I'm hoping that it can be conceptually visible. Usually I use a PowerPoint for this, but this is not the right medium for it. So traditionally, the law has recognized three categories of entities that distribute, entities that are kind of broadly press entities. One was so-called publishers. Newspapers, magazines, book publishers. They were liable for for real defamation or invasion of privacy or whatever they published. So if you're a newspaper and you publish an ad or a letter to the editor, you're going to be liable for it, even if you're not the one who wrote it. A second category were so-called distributors. Classic examples are bookstores, libraries, newsstands. The law long recognized you can't expect a bookstore to know what's on every page of every book that it covers, or a newsstand. Every day the newsstand owner reads every newspaper that it sells. No, can't be. So as a result, they were liable potentially, but only under what I call today a notice and takedown theory, which is that once you're alerted that certain material is libelous, or at least is likely libelous, likely defamatory, then in that case, you would be liable for continuing to distribute. And then the third category were what I might call platforms or conduits. Classic example of that are the phone company, or another example, to use a government-owned entity, the mail. And those were categorically immune from liability. So if you're a phone company and somebody calls up and says, this person is using his phone line routinely to defame me. In fact, he's got an outgoing voicemail message or answering machine message where if people call up, you can try it right now. They're going to say all these horrible things about me. The phone company says, none of our business. So, but here's the thing. It used to be that all of the entities that were in this third, categorically immune, protected from litigation category, not only were entitled to allow everything, they were required to allow everything. they were common carriers. They were required to not edit at all, not pick and choose at all. In Section 230, Congress in 1996 deliberately made a choice. It said online platforms, it was before Facebook and Twitter was like America Online, Prodigy, CompuServe, if you remember them, have the immunity of the third category. They're immune like platforms, but they have the powers of the first and second category. They get to pick and choose what to carry. So they're kind of like a bookstore in their right to choose. A bookstore can say, I don't want to carry this book because it expresses views I disapprove of, or has unpleasant language in it, or whatever else. But they have the immunity of the phone company. That was it. But that was a deliberate decision by Congress, because Congress was facing some court opinions that reached the results that I think, Robert, you were suggesting, the famous cases Stratton, Oakmont versus Prodigy, which said you, the platform, have to choose. Either you are going to edit things, in which case you're going to be liable as a newspaper, or maybe as a bookstore, or you're going to not edit things, in which case you're going to be immune from liability, more or less. I oversimplify. Congress wanted to encourage platforms to edit, because at the time the concern where all the platforms were free-for-alls, and a lot of people who didn't like spam and didn't like vulgarity and didn't like pornography would be unable to find something that is a pleasant environment for them. So Congress deliberately told platforms, you get the best of both worlds. You get the editing power, the selection power of bookstores, and yet you get the immunity of phone companies. And the question today is whether Congress may have made a mistake, or whether what made sense back in the more competitive environment of the past no longer makes sense in an environment where Facebook and Twitter are sort of monopoly-ish in their own niche.
Well, Robert, I mean, you'll tell me I don't agree. I don't trust my own knowledge and level of information on this. My appreciation and understanding was not that it gave these platforms the freedoms of publishers, but rather there was a certain framework within which they said you can moderate for illegal, lascivious, and whatever content and otherwise objectionable content, but it was intending to prevent criminality on the web and not intended to empower editorializing with impunity. But I don't know if Robert disagrees with your categorization of that, but I would thought that's sort of an overstatement of what the immunity was intended to be in the first place.
I think historically, you can make an argument that their intention to give them editorial power was that the editorial power would be applied to what you're describing, to illicit activities. They didn't want people to be punished for editorializing, when editorializing would prevent obscenity, prevent, being able to correct fraud, so on and so forth. But what happened is it became interpreted as the broad expansion. There's competing arguments from the legislative intent. There's competing arguments because maybe it wasn't written as well as some people would like, in terms of, what exactly did the good faith provision mean? But in reality, I think what's fairly agreed is that it was written at a time that nobody anticipated our current situation. There wasn't an anticipation at the time they passed it that there would actually be monopolists in the future that would control the public square in certain spaces. And number one, and number two, that would become the primary public square that exists. It's a place where 90% of the debate is held in only about 3 or 4 forums that are controlled by monopolists effectively in those specific spaces. There's no evidence that in the legislative record, at least, that they really anticipated that problem. And the focus was...
That much is true.
Yeah. And so I think the question is, now we have that problem, what do we do about it? And I agree with those that say, if you remove Section 230, you're mostly going to kill a lot of little people who don't have the means to monitor their content to avoid suit. That's where I always thought the best remedy was a carrot stick approach that said you get the continued benefit of Section 230 applying to your editorial and distributive decisions as if you're a public platform, as long as if you're a monopoly, someone with 75% or more, we have a good amount of antitrust law that gives some definition of who that is, and we could write that into law fairly, I think. If you're a monopoly, so it doesn't apply to the little guy, doesn't apply to small platforms, doesn't apply to your community message board. But it would, so Section 230 still has broad immunity for them. But if you're one of the big monopolists, that the condition of your continued publisher editorial distributive immunity is based on you complying with First Amendment standards. There was a brief period of time after I sued Twitter several years ago where Twitter's lawyers were amenable to that idea. My thought process was just incorporate First Amendment principles into your terms of service, because you have all these great. First Amendment doesn't protect stalking. It doesn't protect obscenity. It doesn't protect child pornography. It doesn't protect harassment. It doesn't protect certain kinds of doxing. The things that they said they were worried about is like, there's a lot of ways to already. It doesn't protect imminent incitement. It doesn't protect true threats. So there are ways to deal with that. That accommodate what they said their goal was, but ultimately it's too tempting to have the power of to be a publisher and the power of a distributor with the immunity of a platform is too tempting for any monopolist to have, in my view. That ultimately it will just the value of free speech will be so substantially undermined that we're back into the company town world. And in the company town world, free speech doesn't meaningfully exist, practically speaking. And if we care about that value, we need to restore it. And I think that most big tech companies would take that trade-off. You like the continued benefit of Section 230, and they would like, at least back then, they would prefer the clarity. I think people like Jack Dorsey down deep do not want to be in these constant controversies. They would prefer clarity of rules. I just want to make sure those rules don't end up becoming the kind that get co-opted to benefit the big guy to punish the little guy, because at least that's the history of the regulatory state.
Yeah, and I think, so I very much agree with Robert that this is a matter that is up for discussion, whatever the purpose of 230 was. And I'm pretty sure that it was to give platforms pretty broad authority to decide what to include and what not to, and it's reflected in the text of the statute. That's just that statute enacted in 1996. Doesn't mean that we need to have the same rule 25 years from now, when indeed, instead of being these newfangled upstarts, AOL fighting it out with CompuServe, fighting out with Prodigy, we have a situation where really it's Facebook and nobody else, and Twitter, and it used to be Parler, and then Parler got blacklisted by big tech. So I think this is definitely something we need to be talking about. I also agree that there's always a danger with regulation, that there are going to be unintended effects that are going to often help the incumbents and hurt newcomers. So that's why I'm generally hesitant about new rules that impose regulations on how private property owners use their private property. But hesitant doesn't mean always say no. So that's why we should be having this conversation. The last thing that I think is also a very important point in what Robert is saying is it may well be that platforms, even if they, on one hand, don't want regulation because it restricts their freedom of action, may actually welcome this regulation because it allows them to avoid spending a lot of money on moderation, allows them to avoid having to deal with public pushback for either over moderating or under moderating. They can say, we don't moderate. And when people say, how dare you allow this horrible stuff? They say, our hands are tied. We're sorry, it was Congress that made us do it. That takes the heat off of them. They keep going on making money from selling advertising, which is good for them. By the way, we haven't talked about this yet, but there's a similar question that arises about private employers firing employees based on their political ideology or political expression. The federal anti-discrimination law bans discrimination by large or even medium-sized employers based on race, religion, sex, age, disability, national origin, sexual orientation, gender identity, but not political affiliation or not political expression. That was a deliberate choice made at the time. And there are plausible defenses for that choice. But states, about half the states have, in one form or another, have restrictions on employers firing employees based on their political activity. Sometimes it's limited to based on their election-related campaigning, let's say. But in other states like California, any kind of ideological activism, certainly off the job and maybe even on the job, is protected against employer retaliation. My sense is, on one hand, employers don't much like that because then every time they fire someone, there's a possible basis for an extra possible basis for a lawsuit. But on the other hand, if an employer gets involved in this kind of Twitter mob that is demanding that they fire someone, they don't really want to fire them, but they don't want the political pushback. If they can say, we appreciate your concerns, but California law says we're not allowed to fire him, so don't blame us. That could be a win for them and a win for the employee too. So in some situations, businesses do welcome regulation, sometimes for malign reasons, sometimes for good reasons.
I was just looking up the text to the Unruh Act because I didn't remember if it said and other bases of discrimination. But the argument that I was always thinking is the Unruh Act, which prohibits discrimination on a number of bases. All of these pieces of legislation were intended. My understanding is that they were intended to be illustrative or give examples, but not be exhaustive. And so, if it requires a court clarification to say that political orientation is a protected,
right. So it turns out that.
No, did we lose him?
No, just give him a second. No, go ahead, Eugene.
Yeah, so it turns out to be complicated. The Unruh Civil Rights Act, which is the California ban on discrimination in places of public accommodation, has been read by courts, whether or not rightly, as saying, well, the prohibited bases, race, religion, sex, and the like, they're just illustrative of a broader point that businesses and shops and such shouldn't discriminate based on unjustified criteria. There were some decisions along those lines from California courts. Later, more conservative courts had cut down on those decisions but didn't completely abandon them. And indeed, some of those decisions suggested that discrimination based on political affiliation was prohibited. But that is a very unusual way to read a statute like that. Among other things, because generally speaking, legislatures try to speak, especially when they limit private businesses, relatively clearly, and not just, well, and everything else like it. So for employment discrimination laws, courts, I think, quite correctly say, it says race, it says sex, it says religion, it says national origin, doesn't say politics, doesn't say height or weight, doesn't say appearance, except insofar as it may be linked to race or sex or whatever else. So as a result, the anti-discrimination statutes that only talk about race, sex, and religion, I think quite rightly, don't constrain private businesses any more than the text of the statute suggests. This having been said, there are specific statutes, many of which are older than the bans on race, sex, and religion discrimination, that ban political affiliation discrimination. So California, there are places to look for our Labor Code 1101 and 1102, enacted in 1937. Which specifically prohibit employers from, among other things, enforcing any rules that control the political activities or affiliations of employees. And the sense there wasn't just so much it's unfair to treat people differently based on political affiliation or race or religion, which came later. Rather, the sense was that it's wrong for employers to be able to leverage their economic power over employees into political power over their employees' political activities. Wrong for them to, for example, sway an election by saying, if you advocate for this candidate, I'm going to fire you. So there are such statutes. There haven't been kind of implicitly read into other employment discrimination statutes, the way it did happen in some measure to the Unruh Civil Rights Act for public accommodations. They've been deliberately enacted by legislatures which are concerned about these restraints on speech. By the way, the first of these bans on discrimination based on political activities date back to the late 1860s. And the first bans of discrimination based on the political activity of voting date back to the 1830s and 40s. They really are among the oldest anti-discrimination, employment discrimination laws that exist in the United States.
In my sense is, this is an area where it's who decides. Do you allow the government to control the employment relationship in certain spaces or allow the employer to do so? In my own view, it goes all the way back that the problem of power is one that requires restructuring the employment relationship. I've always been in favor of for-cause limitation on the ability to fire, period. And I think it's what the ordinary person really believes, that the ordinary person thinks once I'm hired, I really shouldn't be fired unless there's an economic reason or justification for it. And that's my instinctual view, even though it's against what some people would call the conventional free market view of the sort of corporate conservative side. And so within that, I mean, I support all these political discrimination limitations on being able to fire. And I think we'll see there's some courts, whether they incorporate public policy doctrine. There's various states that usually they've had a limited interpretation of what it means to be wrongful discharge in violation of public policy. But whether or not some courts in certain jurisdictions for political reasons might be willing to include within that speech-based discrimination. But I think there's going to be increasing legislative reforms needed to clarify what employers can do as political beliefs and social media activity increasingly become the predicate of taking adverse action, whether it's financial services, consumer services, employment opportunities, educational access, all of it in ways that, you know, we probably didn't anticipate even 10 years ago occurring.
Yeah, I presume there's gonna have to be some major movement on it, because you don't discriminate based on religion other than being an ethical and moral reason. You don't do it because of a social cohesion reason. And you start to create tribalism when you can discriminate based on religion. And when they say don't discuss religion and politics at a party, it's because religion and politics are not much different. You have a few major political parties, you have a few major religions, and if you begin to allow religious discrimination, it leads to social discord. And we're going to see it now, because we're seeing political discrimination, political reprisals, politically motivated reprisals, and that is going to cause as much social discord as any other form of discrimination that is currently prohibited. So, well, I'm
inclined to say that's right. I was actually on a call today, which I think was overwhelmingly a left to center group. Is my guess. And one of the questions was, why aren't more Republican senators, who I think do not love Donald Trump, voting for impeachment? And the claim was because of this cult of personality that Trump has gotten all these voters under his sway. I don't think it's so much that a lot of voters are that much in love with Trump. Some are, but I think a lot of them see his warts. But their view is that the Democrats are going to try their hardest to blacklist us. They're going to try their hardest to get us fired from our jobs. They're going to try their hardest to go after us in other ways, possibly with speech restrictions. But at the very least, they genuinely hate us. The concern is among many Trump voters, and they're going to, if the more they win, the more likely they are to be able to implement a much broader agenda against us, partly based on politics and partly based on race. The concern of many white voters, I think, being that there is a lot of kind of hostility, or I shouldn't say hostility, that white is being used as a pejorative, that whites are being perceived as being morally culpable for the sins of other whites, and that whether or not you think that's right, whether you think that maybe there should be some understanding of racial culpability or white privilege or whatever else, it's a question that at least the free speech principles is people are entitled to debate. But once that's the perspective people have, they naturally say, I don't care what the abstract morally right answer is as to impeachment. I'm not going to reach out across the aisle. I'm not going to go in for some bipartisan compromises that are going to allow the other side to win, and thus make it easier for them to get me fired, get me blacklisted, get me canceled. So this kind of social tension, I think, makes it much harder to work out deals and work out alliances where alliances would otherwise be very helpful.
There was something that I was going to say in terms of not being in love with Trump. I'm witnessing it in real time, and I started with a clean slate. The impeachment of Donald Trump and the impeachment of free speech, as far as I am concerned, is in fact the censorship of speech based on political lines. And the impeachment of Donald Trump and the attempt to interpret what he said as a form of speech that should be sanctioned, compared to all the other speech that is not sanctioned. We're not talking about any rules and any principles here. We are talking only about politically motivated censorship. And I can understand why there should be no. Oh, Eugene, I'm saying if we're going to impeach,
of course,
Trump,
it's politically motivated.
Well, but then if the discussion is now, and what we're getting to is politically motivated censorship and limitations of freedom of speech, then it's not, we're not talking about freedom of speech anymore. We are talking about a form of, I didn't live through McCarthyism. I can only imagine that this is what it was. If you espouse certain beliefs, blacklisted, go after them and make their lives.
Right. So on one hand, I agree that the McCarthy era is actually a very good parallel to what is being done in many ways, both at universities and in other contexts of trying to get people blacklisted. On the other hand, if all that the McCarthy era was that if somebody gave a pro-communist speech, then maybe they'll get recalled, maybe they'll get voted out of office, and if they're an executive official, by the way, you can impeach cabinet secretaries as well as the president. If they were, let's say, the Secretary of Labor who gave a pro-communist speech, if he were impeached for that, I think we'd have a very different reaction to the McCarthy era. The fact is that while I don't think that what President Trump said on January 6th was incitement in the constitutionally unprotected, in the sense of constitutionally unprotected incitement, his job is to see that the laws are faithfully enforced. His job is not just to incite crowds, his job is to calm crowds down. His job is not just not to intentionally promote violence, but his job is not to recklessly say things that might yield to violence. So I think he is quite culpable, not as a matter of kind of constitutionally unprotected speech, but as a matter of dereliction of his duties. He is quite culpable for his speech on January 6th. Now, this having been said, I'm not sure that that's a basis for impeachment, especially now that he's no longer in office. And there are real political costs, I think, to continuing this, especially if what you're looking for is unity, as President Biden is saying he is, which would be very good. This is, I think, undermines unity rather than advances it. But Trump made himself quite rightly a target in this kind of situation by his at least reckless behavior on January 6th. And in general also, whatever he may have been the arguments for there being various levels of election fraud, again, your job as the president is also to try to at some point say, look, it's not good for the country to have this keep on going. And I think he failed in that job, especially since it seems very unlikely that whatever the level of fraud was enough to sway, 5 states that would have to be swayed in order to change the election result, or if not 5, certainly several. So I think that he is quite culpable, and the question of whether he would be impeached or not, I think, is a quite different question of what kind of speech should be tolerated among ordinary citizens.
Well, and if I'm going to, and this is where
I'm sorry.
I'll let Robert. I know Robert wants to say something after this, but if that's the new level of culpability that is going to be applied with political blinders on, I made a tweet earlier today as a sort of a tongue-in-cheek joke because I don't think it's culpable. But then Alexandria Ocasio-Cortez says, if Biden doesn't give us what we want in terms of forgiving student loan, it's going to be a question of public pressure. What does that mean? Because that means to me the exact same thing as fight like hell for your country. When Maxine Waters says form a crowd and harass them, kick them out of restaurants, what does that mean? When Nancy Pelosi says, or I forget who else it was, riots in the street and they're going to continue, what does that mean? So,
I certainly think that legislators, to the extent that legislators are fomenting riots, even recklessly, I think that there ought to be some admonitions by their respective houses for that. The difference is, of course, the impeachment process doesn't apply to legislators. There's a purely internal legislative process. And the other thing is it is more dangerous when it is the president, because there's only one of him. At least the legislators you can outvote if they're doing something really stupid. Not if they're saying something just as such, but if they're in office, continue to be in office after saying that, their potential power is not as great as the president's. But I think if we have a norm where legislators, if they seem to be abetting rioters and are kind of encouraging, even with a wink wink, or maybe not even deliberately, but recklessly saying things that are promoting riots, that they would be disciplined by the legislature, that seems to be a perfectly sensible standard to hold our elected officials to, even if that's not the standard that I would use to decide whether to imprison someone or even fire them.
Robert, you got something to say?
I mean, I think my own view is that going into the broader topic of weaponizing methods available to punish speech is I just generally disfavor as a reflexive reaction weaponizing anything that effectively punishes speech that's otherwise protected speech, whether it's the power of expulsion, the power of impeachment, the power of licensure, the power of employment, the power of educational access, the power of tenure, whatever it is. I don't want that power to be weaponized in a way to punish someone's speech if that speech is something we recognize as constitutionally otherwise protected, even if it's not protected against that particular actor taking that particular action. It's something culturally and socially I believe should be done. So I think that's my concern. Is it'd be one thing if the popular perception amongst Trump supporters was that impeachment is that this was limited to Trump. They were not trying to create a precedent to weaponize whatever tool of power they have available to them, wherever they have it, to punish someone whose speech they don't like. But it feels like the Trump impeachment, the Marjorie Taylor Greene expulsion from committees, aside from its relative unprecedented history, though they also tried to impeach Andrew Johnson for giving a speech. I think it was the 10th article of impeachment, ultimately rejected by the Senate. But is that it's part of a broader pattern, that it feels like if your speech is the wrong speech, all of a sudden you can't use your bank account tomorrow. All of a sudden you can't get a contract. All of a sudden you can't get a license. All of a sudden, if you have a license, you might lose it. All of a sudden your employment may be gone. All the means of survival may be stripped from you, not just in the big tech social media space in terms of being able to be heard and being able to speak and having and being able to hear the speakers you want to hear, which is really part of the First Amendment's idea of protection of free speech, is protecting the audience's right to choose and debate. Is all of that is at jeopardy because of this constant weaponizing of any tool available to punish what appears to be speech that's otherwise protected.
Well, so I think that with that, I agree that part of the concern that people have is that, especially like with part of the House manager's statement about impeachment was, well, his speech was unprotected. It could be criminally punishable. And then anybody looks at it and says, well, since the criminal law does not set up one standard for the president, another standard for everybody else, they're essentially saying that anybody else who gives this kind of speech could be criminally punished. So with that, I agree. This having been said, we have to draw distinctions between political retaliation in the context, or I shouldn't say political retaliation because that can mean many things, but retaliation based on speech and political activity within the context of politics and politicians versus other contexts. So Marjorie Taylor Greene is an excellent example. So let's say that somebody gets elected to office as a Republican, and this is in a Republican-controlled House. And then they change parties. They say, I'm going to be a Democrat. That is fully constitutionally protected. Nobody could throw you in prison for changing parties. In fact, you can't even be removed from office for that, I think. You could be recalled in states that allow recall, but federal constitution does not allow recall of federal officers. Could you be stripped of your committee chairmanship because you were a committee chair or even a committee member because you were a member of the majority party? Now you're a member of the minority party. Let them decide if they want to have you as a ranking member, but you're not going to be a chair anymore. Of course you can. That's the nature of the legislative process that we put, and it's not just if you switch parties. If you do something, if you show real disloyalty to the caucus, you risk possibly losing particular positions. In fact, a lot of times you got the position on a committee is by showing loyalty to the caucus. That is to say, loyalty to the establishment of the majority of the party in the legislature. So it seems perfectly sensible for me. From a First Amendment perspective, it may be bad politics in various ways. It may set a bad precedent just in the Washington, D.C. world of tit-for-tat. So it may be imprudent in some respects, but it seems to me perfectly permissible to say, look, if you say things that show that you're a kook or an anti-Semite, Jewish space lasers, this is what she was saying, is that the Rothschilds were controlling the weather using space lasers. Not only most things that are said about Rothschilds, sort of the suspicion is they're anti-Semitic, they're also they're also extremely foolish. So you might say, we do not want a fool like you on whatever committee. We don't want to be affiliated with a fool like you in the public mind. That, it seems to me, is a perfectly legitimate thing to do in the legislature, even if it wouldn't be a legitimate thing to do when it comes to even firing of private employees, or for that matter, jailing people. And we have to be willing to draw these distinctions, because there's no way we could say the assignment of committee members, or especially of committee leaders, is going to be entirely blind to the person's First Amendment protected activities.
Well, I think it also goes to an election issue. In other words, if the Congress effectively delegates all of its power to committees, can they basically deny someone who's been elected to Congress the ability to be what they were elected to do? And I think I agree that this is a uncertain territory, and historically there's been a lot of discretion given Congress's ability to organize itself, and at some level politics always plays a role. But what was unique to me about this one is, at least in the past, there was a violation of some sort of rules while you were a member of Congress, some violation of some prior agreement. It likes, flipping parties. So now you no longer have the same appointments because of the committee assignments being through the party system. But the question is, what limits are there? Could they go so far as to say, we won't allow any legislation to pass except through certain committee assignments. We won't allow any investigative power except through committee assignments, and just keep going that route to such a way that they could effectively preclude your a constituency voting someone into Congress from having the actual powers of a member of Congress. That's the part of my concern.
Let me give you a clear example. Imagine that some constituency elects a third-party candidate to Congress. The candidate has every right to be a third-party candidate, and the voters have every right to vote for a third-party candidate. But then he shows up, and the parties both say, you're not one of us, so you don't have the support of us. Of course, in many situations, the party might say you can caucus with us, but imagine it is a third party that is really quite disliked for perhaps plausible, perhaps wrong-headed reasons by the other two parties. And he says, well, but wait a minute, my voters are entitled to be represented. Yes, of course they are. You get the same vote on the floor as anybody else. But my voters are entitled to have me be on a committee. Well, not every member is on a committee. For any particular committee, most districts don't have a member there. And what's more, we've long understood that if there's a committee, let's say with 24 members, it may be 15 majority party, 9 minority party. So already we know that if the district exercises its right to elect a minority party member, then the result is they're less likely to have a member on the committee and less likely to have power in the committee. And if they exercise the right to elect a total outsider, well, we're not going to give you the committee you want. Maybe we won't give you any committee at all. It seems to me that is entirely within their legislative discretion. And that's one of the things that the Constitution contemplates by saying every House shall have the power to set the rules of its procedures. Now, there are political constraints. If it looks really small-minded of their part, then it's going to, there's a natural constraint on that. If, for example, if this is causing huge tension back in the home state, maybe one of the parties will take the guy under the wing to try to get the support from the voters next time. Maybe the senators from that state will speak up and use their power. There are all of these political constraints which historically have operated in this context, but they're not First Amendment constraints, it seems to me.
The key, what basically I'm getting to, is what happens if it's functionally the equivalent of expulsion. So in other words, could they, it's one thing, like this committee thing is more nebulous, but could they go further and say, we won't give you a budget, we won't give you an office, we won't give you a staff, we won't, and the ultimate one, we won't allow your vote to count. At some point, doesn't that become functional expulsion?
Right. So that's an interesting question. You could imagine if we don't allow your vote to count, it's a different matter, because the Constitution does speak to votes, at least implicitly in the traditions of the parliaments and that were then adopted in the U.S. Constitution. It doesn't speak to committees. That really is very much part of what except insofar as to say they shall have control of the rules of their own proceedings. So one question is, could the rules of proceedings be such that if they say we will not accept somebody's vote, that's functionally equivalent to expulsion, which the Constitution allows Congress to do, but requires particular procedures for that? Maybe that wouldn't be followed here. It's an interesting question. But stripping somebody of committee membership, which again, the longstanding tradition is what committees you're on, whether you're on the plum committees or not, and how many members of each party are represented, depends a lot on your exercise of your First Amendment protected rights. That if you exercise your First Amendment protected rights to sharply insult your party leadership every chance you have ever to do that, but you're not going to get the committee's assignments that you want, and that's an important way in which parties maintain party discipline for their legislative agendas. That's very much within the boundaries, it seems to me, of American traditions, and not something that raises concerns of unconstitutionality, as opposed to prudence or even-handedness or broad-mindedness or what have you. And again, remember, the Marjorie Taylor Greene stuff, this is pretty egregious. This isn't just she has the wrong view on subject X. She comes
I understand that
as somebody who's both, yeah.
But once we go there, as part of it is, at some point, we have to define what is constitutionally protected congressional activity within the what's the functional equivalent to expulsion, and the question becomes whether committee assignment could come within that. I agree that historically it has not. Of my own view is I think the Congress would function much more little d democratically if in fact committee assignments were randomly assigned, given how much power of Congress members has been delegated effectively to committees over the past, well, you could argue a different time, but definitely over the past 30 or 40 years, the power to be on a certain committee increasingly is the power of what you have as a member of Congress. But that's a separate question for another day. But the other one was just, once we go down the path of we're going to use whatever tools we have available to us, whatever levers we have available to us to start punishing dissident speech, different than, in a way that has not been quite done like this before. I think it's the broader cultural statement that's made of this is what it was. If people thought it was limited to Taylor Greene because of unique, but there again, it's like people can find statements by other current and sitting members of Congress that are that large numbers of the public would consider comparably crazy, and some of those statements they made while they were members of Congress, as opposed to a lot of Taylor Greene's comments being before she was even took the oath. That was my other problem.
And I'm sure the Republicans will work. Right. I'm sure the Republicans will work very hard to use this as a precedent for the future. And that's also an important point, I think, that Jonathan Rauch, who's a great commentator on American politics, had something, I think, during the Clinton administration. He said, for all of the New Testament talk in Washington, it's an Old Testament town. It believes in the law of an eye for an eye. So if something is done to you, you will most certainly do it unto the other guy when you are next in power. And that is something that needs to be remembered. And I think that's absolutely right. And that is a good reason to limit that kind of action. But again, I do think it's very important to draw the, pardon?
No, I was going to say, Eugene, it's a good reason to limit the power, or it's a good reason to ensure that once you're in power, you never come out of power, which is specifically one of the concerns that a lot of people have right now.
Also very bad. Absolutely. But again, I think we have to distinguish. It's impossible not to distinguish between actions based on speech when it comes to high-level office holders. By the way, similar things come up in the executive branch. You say something as the secretary of something or other, or the undersecretary of something or other, that is perfectly protected by the Constitution, may be perfectly true, but is contrary to the agenda of your bosses, you're fired. And that's actually an important way of making sure that the executive branch accomplishes that which the president was elected for. So I think we have to be able to distinguish firings based on politics and based on political speech when it comes to executive branch officials, or quasi-firings like recalls or impeachments, or stripping people of legislative positions and the like, from the same actions being done either to very low-level employees or to private employees or throwing people in jail or whatever else. We can't treat them the same way. I understand why one can bleed over into the other, but we have to be able to maintain some distinction, because otherwise government can't function the way we expect it to function.
You might be hearing a dog barking upstairs, but Eugene, I wanted to come back to one thing you said before about Trump's dereliction of duty in the speech that he gave.
Yeah.
And it's an interesting thing because the idea is, and this is what I'm noticing, is there's censorship of free speech on the one hand, but the flip side to that is there's also compulsion of speech. And you have some people saying this is what Trump should have said, and we don't like what he did say because we wanted him to say something else. And it's sort of like a political compulsion to say certain things and to express yourself the way your political adversaries want you to, which is ultimately the end goal of all of this. Come down with the iron hammer on Trump as an example to now Ted Cruz's. Be careful what you say. Say it the way we like you. We want you to say it as your ideological political adversaries, which is exactly the opposite of what politics is. And Trump's he has certain obligations to the country and to both parties. And then he also has, an obligation to the 75 million people who voted for him to sort of quell their concerns and to potentially rally them for the next election, not rally them to storm Capitol Hill, which I don't think most people think was anything of the object of his speech. But he has, diverging obligations. And the question I'm asking myself now, having watched this in real time, had Trump done nothing else than read that Time article that came out after January 6th, had he done nothing else but read that to the crowd, I think the effect of that would have been far worse than the speech he actually gave.
Maybe.
And in which case,
it's an interesting question. Well, but one important thing also to remember is that the Constitution in this, as in so many other things, aims to protect us from various kinds of maladies through procedural rules. And the procedural rule here is it takes 2/3 of the Senate to convict. So while it's true that impeachment is increasingly being used by both the Republicans in 1998 against Clinton and by Democrats against Trump last year and this year as a bit of political theater, regardless of whether they're going to get a conviction, the fact is somebody isn't going to be removed from office. Weird thing to think about given that Trump has already left office, but generally we're speaking about the precedent for the future, removed from office without 2/3 support among the Senate, which throughout most of American history and I think all of recent history has required some degree of bipartisanship. So I think that is the important check on the impeachment power here, that if a president does something that so alienates 2/3 of the Senate, which will almost always include a considerable number of members of his own party, that they are willing to do that. And what will they do in a typical situation? Not this one, but in a typical situation, that just means he'll be replaced by the vice president, who will often be pretty simpatico with him. So it's not like even the opposite party thinks we're going to get that much out of policy change. It's not we're going to replace him with one of ours. We're going to replace him with another one of theirs. So for all of these reasons, it seems to me as a practical matter, the concern about removal only really arises in situations where a lot of members of your own party, as well as of the other party, are convinced you did something really bad, which my understanding is the conventional wisdom about which way the wind was blowing as to Nixon, which is why Nixon resigned. So the framers didn't set up courts to try to review the impeachment process. It's pretty clear that it's not reviewable by courts. They didn't set up some substantive rules other than high crimes or misdemeanors, which my sense is, I'm not a historian of impeachment, my sense is a pretty variable, flexible process. Or flexible standard, substantive standard. They set up a procedural rule. You got to have a majority in the House to impeach, which is to say kind of to indict, to put on trial, but then 2/3 of the Senate to convict. And that's a high bar. And if it's surmounted, then there's probably something to the attempt to remove the person.
Well, I would say only one thing about the tit for tat, and it's the interesting observation about being replaced by the vice president. I don't think this is politically motivated. I don't see as much of the tit for tat as one would expect. Maybe it's just because of the balance of power right now in Washington, but I'm seeing a lot of tits and not a lot of tats, so to speak. There's been a lot of weaponizing of stuff that I have not seen reciprocated, but it might only be because the Republicans don't yet have the power to capitalize off that reciprocation, so to speak. And I don't see the Republicans.
The filibuster was rejected by the Democrats for lower court judges, for appellate court judges, and then of course it was rejected by the Republicans for Supreme Court justices. I'm not saying either one necessarily got it wrong, but that's exactly it's exactly what what Mitch McConnell warned, I think it was Schumer about back when the Democrats rejected the filibuster for appellate judges, and that's exactly what happened, because that's exactly the way the tit-for-tat process does indeed operate. One other thing I think to keep in mind, and I hope the Democrats, at least some Democrats I'm sure, are keeping it in mind. The presidential election was pretty close. The Senate is 50-50 literally. The House, if I recall the numbers correctly, is 222 to 213. So it's 9-vote difference. So five district could swing control of the House. So my hope is that both parties will realize that things are so close and they're in danger of either losing their power or of not getting the opportunity to regain power, that they're going to realize that that extra division and extra escalation is going to end up looking bad for them. And my fear is that maybe the base and swing voters like the division and like the escalation and would reward the party that does that. So that's, I think, what we'll see. But again, I think it is the structural realities, the 2/3 requirement for conviction in impeachment. The fact that the House and the Senate are basically closer now put together than I think at any time in my lifetime. Those are the things that I think are going to help put things on an even keel, if anything could.
All right. What do we say?
David, what's your thoughts on the news coming out of the BC courts with regards to compelled speech with the transgendered issue?
So I covered that decision. It's a unique decision because people are saying it's compelled speech, whereas when I'm reading the decision, it was about cops repeatedly and deliberately misgendering an individual, and there might have been other context to it. So I read the decision. I didn't see the evidence, and I didn't, read the evidence. I read it sort of more as something that might be more akin to actual malicious harassment and not misgendering someone in the sense that most people appreciated. But I don't know the nuances of that decision. I just know there was a lot more to the context than just misgendering. There was some other treatment issues, and they had a history. So it's not. I don't think it's quite as black and white, but it's the slippery slope that we seem to be on.
Robert, any questions, Robert? You've been quiet the whole time.
No, just I got to wrap up is about it. So I think all good points. I think the main thing about there's definitely a difference between a political actor's speech and a non-political actor's speech, particularly when other political bodies have the power and authority to discipline or resolve it. I think the problem or concern is amongst particularly people on the right is that they see the motive as the problem. In other words, if they really thought that this was specific to Trump or specific to Taylor Greene, and it was an isolated incident, and it was not part of a broader pattern, and you couldn't see clear evidence of hypocritical application. I mean, to have someone like Raskin, who spent the entire summer justifying and rationalizing all of the violence taking place all across the country, and then get up on your high horse and say you're deeply disturbed by speech that could be misinterpreted, everybody knows it's a fraud. I mean, that other than those who are already his patrons and supporters. And I think the bigger problem is they see this as messages to them. In other words, they don't see Trump, going back to the point Eugene made towards the very beginning, which is the reason why there isn't support for any kind of impeachment conviction in part is because large parts of Trump's base see this as a message to them, not as a message to Trump. They see this as a broader pattern. They see not only hypocritical application.
It's a broad left-wing conspiracy.
Yeah, of a kind. Yes, to paraphrase Hillary Clinton from back in the day. So but they see that the belief in weaponizing any tool of power they have available to them to harm people that disagree with them, and they see because of that common motive, even though there's clear legal differences between impeachment and committee exclusion and employment and everyday social media access and financial, all of that. There's definitely a difference. for a lot of voters and people, they don't think it is a difference because they think it's all part of the same pattern, that it's weaved together as part of the same motivation. And it goes to why they're concerned and reacting to the way they are to Trump's impeachment, is they're like, okay, they're going to use this as a precedent to come after me,
Right.
my local job.
Right. I think there's a very great deal of truth to that. I do think that's what's going on, and people are feeling embattled, and reasonably so. And that makes it a lot harder to sort of step aside from one's politics and to say, what's the right policy approach in some abstract sense. Because if you're afraid that you're going to be fired, you're going to be canceled, all these things will happen to you, you naturally look for your allies. And you don't abandon your allies in the interests of the right thing, even the right thing for the country, where they seem to be the only ones who potentially are standing between you and the things you rightly fear.
I mean, I think that sums it up pretty well. I
Yep.
got to hop off here.